This is Anne Marie, the Anti-HR HR lady, and in this video, I want to tell you about 5 critical steps you need to take before you negotiate a separation agreement. First, this is the Anti-HR channel, and on this channel, I talk all things employee workplace rights and HR. I try to provide information to help employees better navigate human resources and also to better understand their workplace rights so that they know how and when to assert them if they believe that their workplace rights are being violated. So if that's of interest to you, please hit the like button, hit the subscribe button, and please share this video with a friend and leave constructive comments. So today I want to share a little bit about 5 things you need to do before you negotiate a separation agreement. So we are getting, summer's almost over and we're getting into the fall. And a lot of jobs that are on a 12-month financial year often lay people off in the last 3 months of the year. It's sad, but it's true. A lot of people get laid off right before the holiday season. And often, as I've explained in past videos, employers use layoff processes to get rid of employees that they see as troublemakers, often employees who've raised concerns about workplace issues. And so they will put a separation agreement in front of people, and people think it's under the guise of a layoff or reorganization, and they just sign on the dotted line, and it doesn't occur to them that they're really being laid off because the employer has determined that the employee might be a liability risk for them, and so they get rid of them. Also, sometimes when you go to your employer and you raise concerns about discrimination in your workplace and you present documentation or evidence that more likely than not this is actually taking place, they'll do an investigation. They'll come back and tell you they haven't found any discrimination. And then 3 to 6 months later, you might be told that your job is being eliminated or that you're being otherwise reorganized. Sometimes they may tell you that you have the option of finding another position in the company, but then of course you find that you can't find the position. And if you can't find that position, you of course will have to leave your position within a certain period of time. These are all things that employers do when they think that you're a risk because you have raised issues around discrimination or other wrongdoing in your workplace. So I always tell people a decision to complain is often a decision to leave. So you need to have a strategy in place, and going to HR is not a strategy. It's part of a strategy, but it's not a strategy in and of itself. And so if you have no plan beyond going to HR, then they're going to make a plan for you and you might not like the plan. So have a plan about what happens after you complain. And so one of the things that can often happen is you get presented with a separation agreement with severance. Or if you work the strategies that I teach my clients, you ask for one and you get one, and then the real fun begins because now you've got to negotiate it. So these are 5 things I think you need to think about before you get into that. One last thing I want to, share some information with you guys before I go over the 5 steps is I'm talking a lot about separation agreements because I know that these things come up around the end of the year. We're getting into the last couple months of the year. Yes, I cannot believe summer is almost over, but in fact, it almost is over. And I am getting ready to put out a course to teach you guys how to effectively negotiate separation agreements, because it's something that people really fall down on. They may get all the way to the part where they get their employer to offer to pay them. They follow the right steps and they get them to do everything they want them to do. And then they agree to really bad terms when a separation agreement gets put in front of them. So I am putting together a course called Mastering Separation Agreements that's going to teach you how to negotiate the negotiation of separations with severance so that you're getting what you want and your employer is not the one that just walks away with everything that they wanted, including buying back their liability from you for a pittance and for a song. Okay, so I'm going to be putting that out. It's going to come out very soon. I'll be sharing more information first with my subscribers to my website. So if you think this is something you'd be interested in, make sure you're subscribed to my website, because the information about the course and the links for the course are going to go to those people who are subscribed to my website first, and then I will be sharing it with the general public on YouTube and other places. So if this is something that you want to get access to, subscribe to my website. I will be providing an early bird discounted price, deeply discounted price, and I will only be selling a certain number of slots at that price. And so if you think you're going to be interested in grabbing the course, make sure you subscribe to my website so that you will get the link first and you'll be able to grab access while it is on sale. Okay, so done with the commercial for that. Let's talk about this because it's really, really important. So the first thing that you need to think through is that you need to understand your leverage. You need to understand what leverage you have in this process. And so, as I said, often, an employer almost never will offer to pay you anything unless they're trying to protect something, which is ending up in court down the road, right? They're trying to protect themselves from litigation in the future. And so a lot of times they will have employees sign separations with severance as parts of layoffs. They will tell you that they're reorganizing or they're eliminating your job when they're actually getting rid of you because you complained about something that could have exposed them, and they want to make sure that they're not going to have to deal with you later, so they offer you a separation with severance. But you need to understand what kind of leverage you have before you agree to any terms. So it's very important for you to, do the assessment of, did you go to HR and ever complain about anything? Are there any incidents that occurred where you were interviewed as a part of an investigation or anything like that? You might have leverage that you don't realize that you have. So make sure you assess your leverage and understand your leverage before you just sign on the dotted line. Because like I said, if they're offering to pay you, it's not out of the goodness of their heart. They're offering to pay you because they're trying to protect themselves from you later. The next thing that you want to make sure that you do before signing any separation agreement or even negotiating is consulting with an expert. In many cases, that's going to be an attorney, or it could be someone like me. There are not a lot of people out there like me, so a lot of times people go to a lawyer and they get advice, and that's a smart thing to do. So if you don't have access to someone like me, who's an HR expert as well as a lawyer, you should make sure you talk to an attorney before you sign. And even if you successfully negotiate all the terms to your liking, which I help my clients to do, I still always advise that they have an attorney just look it over, and I advise them about how to negotiate even that with the attorney, right? Because if you're hiring an attorney just to look at terms and make sure they comply with the law in your state, is very different than hiring an attorney to get, to do all the negotiating and to talk to your employer and to threaten to sue them and all those kinds of things. It's completely different process. So you have to understand how to use an attorney in order to make sure that you don't end up paying money that you don't need to pay, right? But make sure you get advice. I do not ever recommend that anyone sign a separation agreement received from their employer without having a legal professional look at it in some shape or form. So even if you successfully ask for one and they agree to give it to you, and then you follow the steps that I give people and the advice that I give people, and you successfully negotiate an agreement that has all the terms and everything that is what you want and need in there, I still think the better part of valor is to pay somebody a couple $100s and have them look at it and make sure that there's nothing in there that violates provisions in your state as well as federal, because there's certain things that are supposed to be in an agreement to comply with the law. And I always just think it's better safe than sorry to do that. So consult with an expert before you sign a separation agreement. Number 3 is, again, very much related to number 2 in consulting an expert, is to know the law, right? And have an idea of the law and have an idea of your workplace rights, because that's how you know if your employer has done something to violate your workplace rights. One of the reasons why I put together that roadmap to helping employees understand their workplace rights, which is an ebook that I put together, is because I want people to know if their employer has done something wrong. Right? Because most people don't even know about the laws that exist, so there's no way they're going to know whether or not their employer is actually waiving that separation agreement in their face, because they actually did something wrong, but they don't want you to know they did something wrong. So they get you to sign something before you even figure out that they did something wrong. They could have violated your ADA rights, which is age discrimination, ADEA, which is Age Discrimination Employment Act. They could have violated the Americans with Disabilities Act, which is the ADA. They could have violated your Family Medical Leave Act, FMLA rights. They could have violated any number of laws, right? Not just that somebody discriminated or, said something racially discriminatory or did something racially discriminatory, a lot of what employers are doing wrong nowadays is they're violating other laws. Recently, Microsoft was ordered to pay over $14 million by the state of California for violation of Parental and Family Medical Leave Act laws, California's provisions. So they're out here breaking all kinds of workplace laws, right? Because these big companies, they know what the law is, and a lot of them break it anyway because they just don't care. And they know that most of you don't even know that some of these laws exist. So they just blithely go along and they violate till somebody finally goes and files a complaint or files a lawsuit, and then they get ordered to pay. Whether they actually ever pay any of that $14 million is a whole other conversation, right? But they were just ordered to pay recently, I think it's 14.2 or 14.4, but it's about $14 million by the state of California because of violations of that state's Parental and Family Leave Act. So don't just think about discrimination as the only thing that your employer might be doing. Many employers are also stealing wages from people and violating the Fair Labor Standards Act. They're not paying people overtime that should be getting overtime. There are laws about how many hours that you have to work before you can be classified as a salaried full-time employee that allows your employer not to pay you overtime. And many of these employers are violating those rules. So there's lots of different places where people can end up paying you and you don't know why they're paying you, right? So make sure have a good understanding of the law. And that's why that roadmap, that's why I created it, because I want people to at least have a basic understanding of key laws that exist to protect them. And so they have a sense of, and I also put in there things to look out for to let you know whether your employer might be violating some of these rules, right? They're in the ebook. So it's going to be linked to this video. If you know that you don't know this stuff, grab a copy, keep it, on your computer, keep it handy so that you can refer to it, because they are out here breaking laws left and right. That I definitely know. And it's not just around discrimination and anti-discrimination rules. They're breaking all kinds of rules because employees don't know. So the third thing is to have an understanding of the law before you sign on the dotted line. The fourth thing is to evaluate both the financial and the non-financial terms in the agreement, right? Everybody gets very hung up on how much money they're going to get. People always, that's the first thing they want to say to me. So how much money do you think I'm going to get? And I always tell them that's the wrong question. Because the first thing is, if you don't have enough facts in your favor, ain't nobody paying you one dime. So don't focus on how much you're going to get. Focus on whether you have facts that would make an employer want to pay you in the first place, right? And then the other thing is, think about the other things that are important to you besides the money. And a lot of people leave very important aspects out and allow their employer to dictate those terms because they haven't thought beyond how much money they're going to get, right? So what's important to think about, one thing that I always tell people to ask for is to make sure that their employer puts a clause in their agreement where they agree to not do anything to keep the employee from filing for unemployment benefits. Because in many cases, even when you get paid a severance, you can also go collect unemployment. Now, some states may reduce your unemployment based on the size of the severance you get, because some of them will ask, but many of them don't even ask whether you got a severance. So if you file for unemployment and your employer does not do anything to challenge your unemployment filing, you also get to collect your unemployment. So I often tell people, make sure that your employer puts something in there that specifically, affirmatively says that they will not take any action to block your ability to file and receive unemployment after termination of your employment, right? And because employers can, in fact, challenge your unemployment claim and say that you, left for multiple reasons. There are several grounds under which an employer can challenge your unemployment claim. I have personally went down and challenged someone's unemployment and won. So I just want you to know that it's important for you to think about things like that. There are also things that you need to think about around what you want your employer to say about you when you leave employment. about professional references. All of these things are things that you also want to think about, and they're things that people don't think about, right? And so one of the reasons I'm putting together this training is because I want to teach people what to look for, and I also want to teach them how to negotiate, what to actually ask for, and how to go about asking it for it, because everybody gets hung up on how much money they're going to ask for, and they forget about some of these other things that are just as important as how much money they're going to get. So number 4 is evaluate the financial as well as the non-financial terms before you sign anything. And number 5 might seem like it goes without saying, but apparently it doesn't based on the conversation that I have with people. Number 5 is take your time. Do not be rushed into signing anything. Under no circumstance should an employer be presenting an agreement to you and demanding that you sign it right on the spot. They also not, whether it's implicit or explicit, they should not be demanding that you sign it on the spot. The other thing that you need to understand is that if you are over the age of 40, there are provisions in the Age Discrimination in Employment Act, right, that specifically protect people over the age of 40. And so there's specific amounts of time that you are supposed to be given to review and seek advice when you are provided with a separation with severance agreement when you are over the age of 40. And there should actually be provisions that indicate that in the agreement. So especially if you're over 40, but even if you're not, do not feel rushed or coerced or pressured into signing any separation agreement, especially not on the spot. You should always be given time. Now, if you're younger than 40, you're going to be given less time than if you're over 40, but you should never be expected to sign on the spot. And you should be told exactly how much time you have, right? And in some jurisdictions, they're even required to tell you that you should seek legal counsel, but it doesn't apply everywhere. But make sure that you do not allow any employer to make you feel rushed that you must sign right away. Do not sign any separation agreement that you have not carefully read. And if there are things that you don't understand, I recommend underlining them, highlighting them with a highlighter, and then speaking to an expert to make sure you understand what you are signing. I also have a separation agreement checklist on my website that's available to help people kind of understand what some of the key terms that they may see, pretty common provisions that are often, almost always in separation agreements that people should recognize and understand. I put them in the checklist just because I just want people to have a better understanding of some of these things. It doesn't cover every single term because separation agreements, none of them are exactly the same. But there's certain common provisions that are in almost every agreement, and I have listed what they are in the separation checklist because I want people to have a better understanding of this. But do not be rushed. Take your time. Okay? So the 5 things, as I just said, that you need to remember are the following. 1, understand the leverage you have. 2, consult with an expert. 3, know your rights. 4, evaluate the financial and the non-financial terms. And number 5, take your time. Don't be rushed. Okay? I hope this helps you understand the things that you need to think about before you sign any separation agreement with severance. And again, as I said, I'm putting together a training to get people better prepared for these kinds of things and better educated about mastering the negotiations of separation agreements, the separation with severance agreements, and also just making sure people are better positioned to negotiate these things and understand them. And I will be announcing that. So if you are not subscribed to my website, make sure you're subscribed. Information about my website and subscribing will be in the description of this video. I really hope it was helpful. Always remember that HR is not your enemy, but they're definitely not your friend. But I am. I'm Anne Marie, and I'll see you in the next video. Bye.